Ms Adrian, before the luncheon adjournment, I was about to get up to paragraph 27 of Mr AWH's statement. At paragraph 27, he says, "I did not hear back from Ms Jones," and that was the email I took you to before the adjournment from the 23rd of May 2003. "I did not hear back from Ms Jones in relation to the assessment of my complaint, nor was I told of any correspondence about my complaint to Dr Rolleston." Now, at paragraph 28, he says, "On or around the 25th of June 2003, I received a telephone call from Mr Chris Waters." Now, the file note from that telephone call is behind tab 63 of the tender bundle. Could I please have that document? Right, you can see at the top of the page there, the file note is, it's a bit hard to read, the 25th of the 603.
Yes.
And if you scroll down, it's telephone call with AWH. And the beginning of the writing there says, "Advised that we were looking after the complaint and would need to talk to him and his brother," and that's AWO, "further about." He advised that they would both be happy to discuss it and he would arrange for his brother to come to his place. Now, the paragraph underneath that, he said, he advised that he had never reported it to the police, never made a statement about. Again, here clearly the said, he advised that he had never reported it to the police, never made a statement about. WH was encouraged to go to the police at that point. And you'd agree with that?
Yes, although I can only draw the conclusion that Mr Waters might have asked that question to have made that statement.
Well, I mean, I'll take you back to the statement of Mr AWH and I'll take you to paragraph 29. Mr AWH says, "In my conversation with Mr Waters on the 25th of June 2003, I did not understand Mr Waters to be advising me to go to the police, but rather that he was merely inquiring whether I had."
Right, thank you.
Now, you'll understand from Mr AWH's statement that, in fact, he lived in Murwillumbah,
yes,
which was remote from Sydney. The officers from the Healthcare Complaints Commission, in fact, did commence arranging to send an officer up to Murwillumbah. And can I ask that the document behind tab 64 be shown on the screen? You can see that this is an email that's been sent from Chris Waters, and it's sent to 7 of the staff members from the Healthcare Complaints Commission, the subject matter being trip to Murwillumbah. And he starts out, "Now I have your attention, ... And the second paragraph is, "We have received a new file relating to an allegation of sexual assault by a doctor on 2 brothers back in the 1970s that we are investigating." He then says, "I have spoken to one of the brothers, given him the rundown on the difficulties would have with establishing the case. He said that both him and his brother would be willing to give a statement to us." He then says, "We've investigated the doctor for similar incidents that we didn't run it due to the time delay. I still think it is important to interview these 2 people." So you can see by at least the 16th of July 2003 that the Healthcare Complaints Commission was now aware that within this complaint there are 2 people who are saying that they were sexually assaulted as children by Dr Rolleston, and by this date the Healthcare Complaints Commission is aware that there is another person.
It would seem from that statement, yes, so that email.
Right. And finally, the officer says, "Does someone feel like flying to Murwillumbah for the day? Due to the cost and the low risk, I think only one person can go. You'll have to get 2 signed statements plus a stat deck from them. You will also get to have the file. If there's more than one taker, I will make the decision. Now, given this, the Healthcare Complaints Commission is aware of yet another incident. By this time, it's certainly time to actually refer the matter to the police, isn't it?
Yes.
It might also be a time to consult with the Medical Board in relation to Section 66 inquiry, given it's also known by the Commission that this practitioner is still working as a doctor.
And given our standard procedures, I'm sure that discussion was going on. It would be very surprising because, as I understand it, the Medical Board was the one that brought the second matter to our attention again, because our records didn't show that.
Well, there's no evidence at this point in time that any Section 66 inquiry was in the pipeline.
But as I think Professor Walton said this morning, it was at the front of our minds always to have those discussions with the Medical Board, and with the medical advisor from the Medical Board attending all of the assessment committee meetings to assess the complaints against medical practitioners. It was often a source of discussion at that time.
But it might be, I mean, with there being no evidence that, in fact, in this particular case that occurred, this particular case missed out on that thinking.
Well, certainly it wasn't documented if it did occur.
Mm-hmm. Now, looking more generally at the tone of this email, would you agree that it's rather flippant?
It is, it is.
And would you agree that it doesn't convey the seriousness or the gravity of the nature of the complaint that whoever goes to Murwillumbah will be discussing?
Yes, I can see how you could draw that conclusion. However, I think the issue arose around the low risk, wasn't to the complaint, but the risk to the officer going alone, because it was usually standard procedure that 2 officers would go out and interview complainants or witnesses in this particular case. And a decision was made that it was appropriate for 1 person to go.
But in terms of the general tone of this email, it's rather light, isn't it?
That. Yes.
And chatty.
Yes. And Mr. Waters was the team manager for his investigation team.
And would you consider it inappropriate for a senior person to be sending an email to more junior people who are in his legal team?
His investigation team.
In his investigation team. Do you consider the tone of this email inappropriate?
Yes.
Now, at paragraph 32 of AWH's statement, he states that on or around the 31st of October 2003, I missed a meeting with the HCCC that was to happen at my home in Murwillumbah. So a whole series of events happened. The Healthcare Complaints Commission officer did go there, and the interview didn't take place.
No.
AWH at paragraph 38 then says, on or around the 11th of November, I received a letter from Ms O'Gorman concerning the meeting I missed with Mr Waters. Now, the file note from that conversation is at tab 68. If that could be put on the screen, please. Oh, look, I'm sorry, it's tab 65. Now, this is a file note. You can see it's hard to read on the left-hand side of the page there. You can see September 2003, and it says phone call to AWH, re his complaint against Dr R. Now, this officer said, I advised advised I was allocated officer as of Friday, and that's the 12th of September 2003. No date yet for proposed IV. Is that investigation?
Yes, I presume so.
Then September 2003. No date yet for proposed IV. Is that investigation? And again, this is rather neutral in terms of there's no suggestion here that this officer is again encouraging AWH to go to the police.
No.
Mm-hmm. I'm sorry, I'll just be a moment. Now, at paragraph 38, AWH says on or around the 11th of November, he received a letter from Miss O'Gorman, and that's at tab 68 of the bundle. So if I could have that letter up, please. Now, you can see this letter, it's dated the 11th of November, and it's to Mr AWH. Now, if you can stop there, at the top of that, the first paragraph says, I refer to your complaint against Dr Rolleston concerning the allegations of child sexual abuse. And in the second paragraph there, it says, I note that as arranged by telephone on the 23rd of October 2003, Mr Chris Waters attended your home on the 31st of October 2003 for the purpose of taking a statement from you about this matter. However, you were in Queensland visiting relatives. So it's certainly acknowledging that there was an attempt there and there was a failure there. Now, following that acknowledgement, Angela O'Gorman has said, in order to investigate your complaint, the Commission requires specific details about all the incidents of child sexual assault you can recall. Please include any information you can recall about dates, locations and what actually occurred during the relevant consultations with Dr Rolleston. Please record this information on the enclosed complaint form and have the statutory declaration witnessed by a Justice of the Peace or solicitor. If you do not know a Justice of the Peace, one can usually be found at the bank, post office or police station. And then she goes on, once you've completed the complaint form, please return the signed form to the Commission within 14 days of the date of this letter. If the Commission does not receive your written complaint within this time, consideration will have to be given to terminating this matter. Now, on receiving or of receiving this letter, AWH at paragraph 39 of his statement says, I recall feeling very annoyed by the letter. I'd been speaking to the HCCC for 6 months and had given them all the information I had. I may not have known Dr Rolleston's Christian name as they had asked, but I was a young teenager at the time of the abuse. I could not understand what level of detail they were expecting from me, and I had the impression the HCCC wanted to terminate the investigation. Now, having regard to the contents of that letter he received, do you consider that's a legitimate comment? That?
Yes, I do, and I think it's, once again, not an appropriate response given the trauma that Mr AWH had suffered.
At paragraph 40, he further says, on or around the 10th of December 2003, I received a call from Miss O'Gorman saying that the HCCC had not received a statutory declaration or any other particulars about my complaint against Dr Rolleston, and that as a result, the investigation would be terminated or discontinued. Now, further down that same paragraph, he said, "This was a very frustrating experience for me. The HCCC correspondence was happening at a time in my life when I was mentally very upset. I had around this time attempted to commit suicide and was experiencing suicidal thoughts all of the time. The level of technicality, procedures and processes the HCCC was asking from me was overwhelming me. I had naively assumed at the start of my complaint that if I complained to the HCCC that they take care of Dr Rolleston. But the HCCC was insistent on receiving a statutory declaration, and at that time of my life I was unable to provide one." Now, again, having regard to that letter, do you accept that the technicality, the procedures and the processes were in fact likely to be overwhelming to a complainant such as AWH?
Yes, I do, and I certainly acknowledge that. One of the great difficulties for the Commission at that time was the provision in the legislation, that section 23(3), that meant that the Commission must not investigate a complaint without a statutory declaration. I certainly made representations in the time I was Commissioner to have that removed because of that bureaucratic and very high bar for people such as Mr AWH in stressful and situations where they're very unwell, because certainly there were a number of matters where we were managing complaints that this was an extreme difficulty.
Given that statutory roadblock, if you like, to progressing the matter, isn't that precisely the time when the HCCC ought to have referred the matter to the police?
Yes.
And looking back now, this complaint was discontinued, and yet in the knowledge of the Healthcare Complaints Commission, there were three complainants who alleged that they'd been sexually abused as children.
Yes.
The Healthcare Complaints Commission also knew that that practitioner was currently practising, and the Healthcare Complaints Commission also knew that they had not recommended to any of the complainants to go to the police.
That's right.
Reflecting on that now, what do you have to say?
We should have referred formally these matters to the police.
Mm-hmm. Your Honour, I don't have any further questions.
Yes, does anyone else have any questions?
I do, Your Honour.
And I do as well, Your Honour.
Yes, Mr Fagan, you might go second. Does anyone else?
Yes, I do, Your Honour.
Well, Mr Fagan should go last, I think. Probably you should go first. I think.
Thank you, Your Honour. In the 3.5 years that you were...
Better tell everyone who you are again.
I'm sorry, Your Honour. My name is Kumar. I am counsel for AWC. In the 3.5 years that you were Commissioner, that is from June 2000 until 2003, was it your practice that as Commissioner you became aware of the serious complaints held by the Healthcare Complaints Commission?
Yes.
And is it also the case that you regarded child sexual abuse allegations as serious complaints?
Yes.
In the 3.5 years that you were Commissioner, can you estimate how many allegations of historical child sexual abuse you came to have knowledge of?
As far as I can recollect, these were the only two matters that I dealt with in my time at the Commission, and I have no memory of preceding matters. So these are the only two.
So do you say that the only two complaints of historical child sexual abuse were those complaints involving AWC, my client, and AWH?
I have no memory of Mr AWC's complaint. As I said, it's only these documents that have brought this to my attention. Mr AWH's complaint I do have a memory of.
So you say you have no memory of Mr AWC's complaint. However, it was considered by you to be a child sexual abuse allegation which was serious.
Any sexual abuse matters within the Commission were regarded as serious. I have no particular memory of Mr AWC's complaint. However, it would have been dealt with in the manner that we dealt with all sexual assault matters, which was that they were very serious and would ultimately lead to prosecution if the evidence and the matter was fully investigated.
Could a reason for you not having any memory of Mr AWC's complaint be that it was not regarded seriously at the time that you were Commissioner?
I think there is enough evidence that it had been referred immediately into the legal team for investigation, which was a practice at that time, because it had been recognised that it was a very serious matter, warranting investigation and likely to lead to prosecution. And without remembering the particular facts of the case, that course of events was for only those matters that were in the high-risk, serious area.
But Ms Adrian, my client made his complaint in August 1998.
Yes.
And it took the Commission until nearly the end of 2001 to come to a decision regarding the investigation insofar as the investigation was terminated.
Yes, and that is deeply regrettable.
And would you agree that that indicates that it wasn't treated expeditiously?
It certainly wasn't treated expeditiously, but I would challenge and take issue with the fact that we didn't regard it as a serious matter.
In the report, the investigation report that Counsel Assisting took you to, Counsel Assisting took you to the last page of that report, and if I could have document at tab 47 brought up on the screen, please. The last page of that report set out a number of dot points which were the reasons why the Commission decided not to proceed with my client's complaint and to terminate it. In any of those dot points, that is the 3 dot points on that page, do you see regard to the fact that my client's allegations were serious?
No, I don't. However, it was not those matters in those dot points particularly that I would have relied upon to make a decision not to terminate this matter. It would have been the quite substantial legal arguments that are contained further down in that investigation report.
When you say those substantial legal arguments, which ones are you referring to?
In that report, there's matters around the tribunal's response to old cases and the delays, and in hindsight, the advice was flawed, but certainly I had 2 senior legal officers providing that advice to me at the time.
So is it the case that the fact that this was an historical child sexual abuse allegation was a reason that it was terminated, insofar as there was the 19-year delay?
The strong likelihood that any disciplinary action would be permanently stayed was, I think, the flawed advice I was given because of the tribunal's historical response to these matters.
And you say now that that issue of delay would be something that would have been best left to the tribunal to determine?
Absolutely.
And at the 4th dot point, there's reference to there having been no other complaints of this nature against Dr. Rolleston. Do you see that?
Yes.
Did you or your staff check the medical board to see whether there were any other complaints?
Well, certainly on the face of the assessment committee document, the fraud and misconduct cases in relation to the financial mismanagement had been raised. I have no memory that we needed to or checked, and we were in constant discussion with the medical board. A serious matter like this would be one of the regular updates we would have given them in relation to where progress for the investigation was.
But would you agree with me that
There's nothing
doesn't appear anything
in the
this
investigation
document?
report? No.
And in fact, this commission has found a document which does record an earlier complaint to the medical board.
Yes.
Are you aware of that?
Yes, I am.
And so if an inquiry had been made at the time of this investigation report with the medical board,
Yes.
that complaint could have come to light. But it wasn't, was it?
No.
The last dot point refers to the lack of corroborative evidence. But would you agree with me, Ms Adrian, that this report didn't consider the fact that there was corroborative evidence
There was.
in my client's case?
Yes, there was corroborative evidence.
Now, you've had reference to the documents produced by the Healthcare Complaints Commission, and do you agree that nothing in those documents records any Healthcare Complaints Commission employee or any staff at the Commission advising my client that he could report the sexual abuse to the police?
No. Certainly not as specific advice.
You gave evidence that a complaint of child sexual abuse would be escalated. I've set out the dates of my client's complaint. That is, he made the complaint in 1998 and a termination report was made, or a decision, in November 2001. Is it your evidence here today that that timing, that time period, demonstrates that his complaint was escalated?
No, on the face of it, it does not.
Thank you. I have no questions.
Thank you, Commissioner. Ms Adrian, my name is Patrick Griffin. I'm counsel for the Healthcare Complaints Commission and for the current Commissioner, Kieran Pem. Can I ask you questions in relation to two topics? The first one is the question of the assessment process.
Yes.
In 2003, do you accept that when you were undertaking an assessment process, you had three options available to you? Firstly, refer the matter for investigation. Secondly, refer for resolution of one way or another. Or thirdly, to terminate or discontinue.
Yes.
And did the assessment process in reality consist of someone simply reading the complaint and then there was a discussion as to which of those three options to adopt?
On the face of the complaint, I would suggest that there was only one option in relation to an allegation of sexual assault.
I appreciate that, but I'm talking about complaints generally. Somebody read the complaint, then there was a discussion, and then one of those three options was selected.
Yes, but I mean, all the material on the face of it that we took us straight to a decision that it wouldn't need to go for investigation.
But the assessment didn't go any deeper than that, did it? It simply meant reading the complaint on its face.
The discussion was that we must get the statutory declaration as soon as possible and as much information as we can from the complainant and his brother, if possible.
Thank you. Now, on the question of delay, you were taken by counsel assisting to the evidence of Mr Pem.
Yes.
Mr Pem commenced as Deputy Commissioner in April of 2004, and you left in December 2003.
Yes.
That's correct. You were taken particularly to evidence of transcript 14185, where Mr Pem said, when I arrived at the Commission in 2004, it was not uncommon to see delays of 2 and 3 years in files. Do you accept that evidence?
No, I don't.
What was your understanding of the level of delay in December 2003 when you finished?
It's my understanding there were unallocated files because we had reached the view that just loading more and more files to investigation officers was not a useful thing to do. However, the Assistant Commissioner, with her team, did go through a process of priority setting in relation to matters that were in the extremely serious and less serious domains.
So what was your understanding of the level of delay in December 2003 across the range of complaints you had?
It would have been my understanding that there would have been matters that may not have been allocated for a matter of months, but not for 3 to 4 years by any means.
Right. Now, on the question of unallocated files, complaints, Mr. Pym gave evidence that there was a pile of files in a large corner office. Was that the case when you were there, that there was files stacked up in an office?
No.
And he referred to perhaps 700 or 800 files, and in evidence today you responded by saying that was highly improbable.
Yes.
How many files fitted into the category of being unallocated in December 2003?
I have no memory.
No idea?
No idea.
Well, on what basis do you say his figure is highly improbable?
Because it was certainly in December 2003, there was no single office that accumulated files in that way. The Assistant Commissioner, who was working with the investigations managers allocating files, would have had the unallocated files in her office, but certainly at no time would there have been a bulk of files of that nature, other than the number of matters that had come out of the Camden-Campbelltown inquiry, our investigation, where a number of nurses and doctors had been cited for individual investigation. However, those files were not 3 to 4 years old.
Did you subsequently become aware of an audit conducted by Mr. Bill Grant, who came in after you as a temporary commissioner?
No.
Did you subsequently become aware that an audit revealed that there were 600 files that formed a backlog that hadn't been dealt with?
No.
Did you subsequently become aware that there were 300 of those files that were more than 18 months old?
No.
Did you become aware that there were 143 of those files that were more than 3 years old?
No.
And that there was one of the files that was older than 5 years?
No.
So you weren't aware at the time you were Commissioner, and you didn't become aware subsequent to you leaving the Commission of those matters?
Not of the outcome of an audit, no.
Thank you, Commissioner.
Yes, Mr. Fagan.
The transcript will already show that I'm asking questions as Ms. Adrian's counsel.
Yes, the reason for asking people to
So the witness
identify themselves is so that everyone else watching you, because there could be thousands, knows who you are.
I understand that. Ms. Adrian, you referred to the lack of case management technology that hindered the work of investigation. What aspect of case management technology was deficient? What functionality did you not have?
We had no information management system that allowed us to allocate milestones according to the policy and procedures of the Commission that would trigger investigation officer and their manager and the senior staff of the Commission to be able to monitor the case the throughput of matters other than through the individual spreadsheets that each of the managers was developing with the Assistant Commissioner. So there was no mechanism where we could, search the database with confidence that we would find any, multiple complaints about a medical practitioner or another healthcare practitioner, and there was no confidence that we had a means of looking at the individual caseloads of every investigation officer and the legal officers without it being on a manual spreadsheet developed by they in their case and their manager.
Well, was one thing missing the ability to fix times by which responses ought to be obtained or steps be taken in the course of an investigation, and the ability to monitor by electronic inquiry by managers and senior personnel whether this was actually happening.
Yes.
And you've referred to a system which you call Casemate, which had been tendered for and was in course of development when you departed.
Yes.
Is that an electronic management system that did introduce that functionality?
Yes, it was from the very first, in my earliest times at the Commission, we identified that there was no capability within the Commission, and certainly the funding was sought early and was agreed to, and the tender had been granted, and we were working with the developers at that time.
You were dismissed from the position in December 2003.
I was.
Is that right? And at the same time as you were dismissed, were a number of other senior personnel dismissed?
All of the executive were dismissed at that time.
How many people was that?
As I understand it, all the two assistant commissioners and the directors were dismissed, right, and the manager of the legal services team.
That had nothing to do with these sorts of delays, did it, but rather with a dissatisfaction on the part of the government concerning the manner in which there had been investigation of the Macarthur Health Service.
Yes.
Is that right? And did you ever, between when you were dismissed and when Mr. Pem made such observations as he's given evidence of here, did you ever revisit the Commission premises to ascertain what effect there had been upon the handling of cases by the removal of these senior personnel in bulk, peremptorily, as it were?
No. I was not even allowed to go back to my office after my dismissal.
All right. I'll ask that there be brought up document 47 again, and if you would go to the last page of it, the bullet points that you've been asked about by the Council. The second last one is the assertion by this legal officer that there was a strong likelihood that any disciplinary action would be permanently stayed given the lapse of time since the alleged misconduct and the principles espoused in the case law outlined above. You see that?
Yes.
And if you then go back to the bottom of page 3 of the document, there commences the discussion of principles concerning stay of prosecution of complaints that are of considerable age, and that goes on with the citation of authority on the next page, the cases of Walter and Gardner and Heron and McGregor.
Yes.
And then there's another page at page 5 with quotations from judicial decisions, and it continues at the top of page 6. Now, with respect to that legal discussion of the significance of delay and the likelihood of a permanent stay of any disciplinary proceedings, I know you've said that you have a law degree, but have you ever practiced law?
No.
What experience then had you had of the practical application of principles about stay of disciplinary or criminal proceedings?
Very little, and I relied on my legal team to provide me with that advice, and we also, upon occasions, sought counsel advice.
Right. Did you have any anecdotal knowledge of any course of decisions or any disposition of the tribunal in relation to staying disciplinary proceedings for delayed complaints against doctors?
It was my understanding and my advice, and it was anecdotal, that the tribunal took a dim view of matters of the age of such matters as this, and continued to be very critical of the Commission and the Medical Board in bringing these matters forward.
Did you understand that in the context of sexual assault cases?
And that's where I believe the advice was flawed, because it was in relation to clinical decision making, and I accept that now.
Now, this advice here, who did you understand had prepared that?
I think initially that Mr. Swain may have prepared it, or Mr. Harris, who passed it up to Mr. Swain, but would have been passed Mr. Galloway, who was the director at the time.
I think you may have said this, but was Mr. Swain a practising solicitor?
Yes, I understand so.
And Mr. Galloway was his superior?
Yes.
Was he also a practising solicitor?
Yes.
Did you understand what level of experience they had with the sorts of issues that are the subject of those 3 pages of advice here?
Certainly Mr. Swain had been at the Commission for a long time, and I don't know exactly when he joined, but he certainly had a history with the jurisdiction. And I can say I relied on his advice, and his advice generally was sound, and it was certainly I trusted what came my way.
Mr. Swain was still at the Commission until you were dismissed, and I think he was dismissed at the same time, was he not? Mr. Galloway had left in the meantime to take a position with another authority, is that so?
Yes, he did.
And for the duration of their continuance at the Commission whilst you worked with them, did you continue to have confidence in their experience and ability to advise?
I think certainly as I developed an understanding of the jurisdiction, I was much more challenging of advice and exploring advice much more openly than I possibly was at this time. There was no incident that did that, but I guess it was my own confidence in and understanding the jurisdiction.
Well, you're referring to that development of confidence and tendency to explore legal advice throughout the term that you're at the Commission.
Yes.
Very well, thank you.
Yes, any questions, Dr. Bennett?
No, Your Honour.
Yes, thank you. Ms. Adrian,
Thank you, Your Honour.
evidence is now complete and you're excused.
Thank you.
Your Honour, in the course of the questions from Counsel for the Healthcare Complaints Commission and Mr. Pem, some questions were asked of Ms. Adrian in relation to an audit report that was conducted. Would it assist, Your Honour, I
think we should have it. Yeah.
Your Honour, the situation is those instructions were by way of mobile phone. I will obtain the documents and provide them as soon as possible.
Well, if you could, and we'll need to provide them to everyone else. And
yes.
I'll receive it as an exhibit in due course and mark it Exhibit 2731.
I understand the usual procedure of the Commission, Your Honour, but they were the circumstances.
Yeah, I understand. Yes.
Well, Your Honour, Ms. Adrian was the last witness for this case study, and that completes the evidence.
Very well. Have you talked about a program for submissions?
Indeed, I have a draft direction here that has been circulated.
Is it agreed by everyone?
Yeah, apparently so, Your Honour. It's off. I will hand up the direction. Oh.
Well, this is the direction not to publish.
Yeah. There's a second copy of each of those documents, Your Honour, and the first one is seeking a direction in relation to the submissions. The submissions of counsel assisting being required on or by the 19th of June, and written submissions in reply following 4 weeks after that.
Do you need 4 weeks to reply?
My understanding is that that is the standard.
Might be the standard, but this case is confined pretty much. Controversy has been significantly reduced. Do we need 4 weeks?
Would you like to, perhaps we could reduce it to 3 weeks?
Well, I had in mind too, but unless anyone protested it, as this case study is unfolded, it's obviously got 3 segments, but each segment now does not have a lot of controversy in it, I wouldn't have thought. No. What will be important is your submissions to lay it all out. Am I right in that thinking?
I think you are right, Commissioner. There is, however, one issue, and so far as my essentially 4 elements from whom I must take instructions on these things, it may take a little time. I would have thought 3 weeks would well accommodate that, but 2, no. Just a bit tight.
All right, well, we'll reduce it to 3. And then you all have 2 weeks in which to respond to each other. But again, that won't involve very much in this case, but I'll leave that as 2 weeks. And then if there's a need for an oral presentation, we can provide for that in due course. But I would not anticipate that need in this case, frankly. I think it's very unlikely. I'd encourage you to think in those terms, that is, say what you want to say in writing so that we don't delay the process by having to find an oral date. It's always hard to get even 2 commissioners back to the same place at the same time, given the schedule that we have to meet. But obviously, if it's essential, we will, but I'd encourage you to think that it won't be essential. All right, well, with that change, I'll make those directions. And then I'll make the non-publication direction, which is done just to ensure that part of the story isn't out there while the other part's not there. All right. Otherwise, I'll thank everyone for their assistance and we'll adjourn.